Hello everybody, a warm welcome. We, Group 17, are here to explain about Independence of Judiciary, appointment of transfer of judges. So, introduction, significance and principle will be done by Vaishnavi and legal provisions, mechanism will be done by George and instance will be done by John and at last redressal will be done by Sujit Raj. So let's come on. Let's learn some stuffs today. So, I myself, Vaishnavi, here to explain about introduction. So, judicial independence is a crucial intention of maximum fluency system owned upon a deliver neutral and excellent choice and so undermine the legitimacy of the criminal device as a whole, and while they may be close to established consequence on the importance of judiciary independence has a dependent of concept criminal structures make us on a huge variety of selection mechanism and on significance in Indian's constitutional democracy. Independent judiciary is the foundation of a truthful and unbiased and constitutionally balanced society. Judicially independence serves as a protect for the rights and privileges supplied through strained constitution and for the government those rights. And at last, principles. Judicial independence serves as a protect for the rights and privileges supplied through a strained constitution and frozen government and legislative encouragement upon those rights. It serves as a foundation for the guideline of regulation and democracy. Over to George. He will be explaining legal proficiency and mechanism.
Legal provision safeguarding the independence of judiciary. It does not give way to individual or group dictatorship. SP Gupta versus Union of India. In this case, the Indian Supreme Court rejected the central government's claim for protection against disclosure and directed the Union of India to disclose the requested documents. The petitioners sought the disclosure of correspondence between the Law Minister, the Chief Justice of Delhi, and the Chief Justice of India on the appointment and transfer of judges. Also, it sets strict boundaries for the judiciary, a constitutional mechanism for safeguarding the independence of judges, security of tenure. The judges of the Supreme Court and High Court have been given the security of the tenure. Once appointed, they continue to remain in the office till they reach the age of retirement, that is 65 years in the case of judges of Supreme Court and 62 years in the case of judges of the High Court. Salaries and allowances. The salaries and allowance of the judges are a charge on the Consolidated Fund of India in case of Supreme Court judges and the Consolidated Fund of State in the case of High Court judges. Power to punish for contempt. Both the Supreme Court and the High Court have the power to punish any person for the contempt under the Article 129 and Article 215 respectively. Appointment of the judges. Every judge of the Supreme Court shall be appointed by the President by warrant under his or her hand and seal after the consultation with such judges of the Supreme Court and the High Court in the states as President may deem necessary for the purpose and shall hold office until he attains the age of 65 years.
I'm John, and I will be talking about the two instances where judicial independence was challenged. Firstly, the Kesavananda Bharati case. This was the case that established the basic structure doctrine, which states that the values and principles of the Constitution cannot be altered. The verdict was not well received by the government, which at the time was led by Indira Gandhi. On 26 April 1973, one of the judges that disagreed with the verdict of the case, Justice Ajit Nath Ray, was promoted to the position of CGI. This sparked controversy as Ajit was not the senior most judge. In fact, there were three judges more senior to him. This was a blatant attack on judicial independence by the executive and in retrospect has been rightly regarded as a black day for Indian democracy. Next, the collegium system and its flaws. The collegium system has a complete lack of transparency since nobody actually knows how the judges are selected, and the appointments may raise concerns of proprietary, self selection, and nepotism. There was an attempt to reform the corrupt collegium system. The National Judicial Appointments Commission, the NGAC, could guarantee the independence of the system from various corrupt practices and rebuild public confidence in the system, but it was struck down and labeled as unconstitutional.
Hello everyone, this is Sujit Raj here to explain you about the deterioration of constitutional democracy in the country. Whereas inside the chapter of United Nations, the peoples of the sector verify inter alia their dedication to set up conditions under which justice may be maintained to obtain worldwide cooperations in selling and encouraging recognized for human rights and fundamental freedom without any discriminations. Whereas the Universal Declaration of Human Rights enshrines especially the concept of equality before the law, of the presumption of innocence, and of the proper to a honest and public hearing viable, independent and impartial tribunal established by using regulations. One manner to promote judicial independence is by way of granting existence tenure or lengthy tenure for judges, which ideally frees them to decide cases and make ruling according to the guidelines of law, judicial discretions, even though those sections are politically unpopular or hostile via effective hobbies. Now, we have got four models for suggesting redressal. The first one comes like British model, limited veto to executive, usable in special circumstances. Second one, South African model, nature of executive involvement in equal terms of number. Third, American model, strong executive participation. And finally, rule, executive involvement in appointment only and not transfer. Thank you.
We, Group 17, wholeheartedly thank Miss Isha for giving this beautiful opportunity on topic Independence of Judiciary. We learnt so much about those judges and how we got the independence of judiciary. Thank you, ma'am.